Welcome, ladies and gentlemen, to the Your Nation Show, the place where business owners and entrepreneurs just like you come to learn tools and tactics to live more epic lives. I'm your host, John Reinhardt, and beside me is Jace. Jace, you're a lawyer. Talk to me. That's what lawyers do.
Oh, man, I try not to admit that. I admit it as little as possible, but yeah.
The lawyer or the talking part?
Both. I don't like to tell people I'm a lawyer, and I certainly don't like to talk about it. So I thought I'd come on a podcast and talk about how I'm a lawyer.
That is an epic way of dealing with the fear. I think that's really good. So, I love this idea. He sent me a whole list of things that made me sweat profusely. I was like, the whole idea of this, podcast. I was like, this sounds like a great idea. We're going to sit here and we're going to talk about how you could possibly be a criminal, or what you're possibly doing in your business that's not right. And then he sent me this list of wonderful things that made me scared to death. So I hope they scare you too. Are you ready?
Yeah, I'm ready.
All right. What was the first thing on your list?
Well, so in no particular order, I was just sitting down and thinking, what mistakes are, with the preface that most of your audience are entrepreneurs and small business owners, and they're coming here to get epic advice. So I thought, what are some common mistakes I see as an attorney? Now, I don't own a small business, but I deal with a lot of small businesses, a lot of small business owners. And some of the mistakes that I see them making, I wanted to address. So in no particular order, I thought about what are some of the things I've picked up over the past 6-7 years of doing this. And the first one I want to talk about is a work environment. What kind of work environment are you fostering at your business? So
this is beyond culture. This is beyond any of that kind of fun stuff. This is like... what would you say the difference is in between work culture and work environment?
Well, I think environment. I think culture is necessarily tied up in environment. What kind of culture are you fostering there? But also, there's things outside of that. There's other things to be aware of. So, your environment is made up of everyone within your place of business. Mm-hmm. So you're going to have necessarily more experienced older people working there and less experienced younger people working there. And those two are going to have a different culture that they come and they bring to the table. And then hopefully they can mesh, and that's what's going to create your culture at work. But also you have to be aware on the periphery, like these environmental factors of young people, old people, more experienced people, more go-getters, more lazy people. So the environment, I think, is, in my opinion, more encompassing of what you're going to be dealing with as a business owner. So, for example, things I wrote down, just because I've been told I'm in this category, but millennials, right? Millennials.
Oh, great. A
lot of people out there are going to be hiring millennials for their company. They have a different, not just work ethic, but that is some of it. But
in other words, we work our ass off. That is how.
That's true. But millennials also adhere to a different way of thinking. They don't adhere to that, quote, old school way of thinking. And
so what would be the differences?
Well, I think they multitask better, for example. I remember the first time I was taking graduate level classes, and someone had their phone out in class, and the professor kind of looked at him, and the guy scurried to put his phone away, and he said, I don't care. I think you can listen to my lecture and also be on your phone at the same time. Y'all grew up around computers, screens. Y'all are always on it. I think brains are just wired differently, and millennials can multitask better. I think the exposure to technology, an increase in population. There's just more going on. The connectivity of the world these days. I think, in fact, you have to multitask better in order to be successful.
So is that something that you need to be aware of, or is that something you need to foster? Because I don't necessarily agree that anyone multitasks better, because at least in all the studies that I've read, right, there's no such thing as good multitasking. You end up losing productivity through trying to multitask, right, instead of focusing on one task at a time.
So I guess, correct me if I'm wrong, but you're saying it's better to whole-ass one thing than half-ass two things simultaneously.
Yes,
okay,
absolutely.
And that's fair. And I think, yes, very important issues. They need your focus.
Is that just like a cultural thing? You're like, okay, this is how they perceive it. This is how I need to deal with it in order to create a productive work environment.
Right. I just think it's important to be aware that as a business owner, if you go in and see an employee who's a millennial, who's younger, they might be on their phone, right? But you don't know. They may be texting their friend. They may be checking their fantasy football scores, or they may be looking up an answer while their computer is currently doing computer things, data processing or something.
Computer things.
Yes.
I like that. I'm going to use that from now on.
Hey.
When someone asks me, what am I doing on my computer? I'm going to say computer things.
You're more than welcome to have that.
Thank you.
I don't think anyone's going to fight you for it. But that's just look, and this is just one example of how I'm using millennials specifically here because I feel like I can relate to them better. At least I know more of them than I do old curmudgeon people who think that we're doing everything wrong and ruining the world. But a different thing is younger people in the workforce have different motivators. They're more concerned, generally speaking, with job security and quality of life as opposed to titles, for example, or even money. Money's not a huge motivator, or not as big as a motivator for a lot of younger people entering the workforce. So
where does this impact like the law and how we deal with employees and potential problems kind of going forward for business owners?
So I think it's important to remember that anyone can, I don't want to say break the law, but anyone could go against maybe the letter of the law. It doesn't matter how old or young you are, how experienced or inexperienced you are, but it is something to be aware of. I don't think it necessarily, I think it matters for when we get down to maybe points further down on the outline, but it's going to be tailoring your policies to make sure that you're expressing what your rules are, what the guidelines are, what your policies are to a younger audience, to these younger workers that are coming into the workforce. Also, within your work environment, you don't necessarily need what I'm calling a Google or a Silicon Valley type environment where everyone sits on these Swedish balls for chairs and you have mandatory nap time. And I don't know. I've never worked in an environment like that. I can only speculate. And maybe a lot of this is coming out of a place of jealousy that I don't have a place to work like that. But also, I think it's important to avoid what I'm going to call the old school way of thinking, or what I have in my notes here, the Industrial Revolution era way of thinking, And what I mean by that is the old adage that, why in this economy, you're lucky to have it. You should be lucky to have a job. I think that's an antiquated way of thinking. I think that is a simplistic way of thinking. And I think that a job can be something that, hopefully, they say if you love something, if you love what you do, then it's not work, right? But a lot of people aren't fortunate enough to do that. So you need to be cognizant of that in your work environment. What your employees...
Not everybody's dream is your dream.
That's correct. Exactly. So I think quality of work is just important as the type of work. And what I mean quality, like not the product you're putting out, but the fulfillment and satisfaction you get from your job. I think that's I think beforehand that was kind of the unspoken thing. People say, you're lucky to have a job. Well, yeah, but I hate my job. I have to get up and go spend 8 hours somewhere that I don't like. So I think that's something to be cognizant of as an employer. What type of environment are you fostering to make sure your employees have a good quality or a good experience and can enjoy their work? So. Right. Because as you kind of do that, like you also see your productivity go up. The better work environment, the healthier, the more relaxed and work friendly your force is, like the better off you're going to be. I think we've seen that in a lot of different countries. I think one of my favorite books that kind of touches on some of the differences in some of these different types of work environments is the Nordic theory of everything. They were actually specifically talking about like the reasons why different in this case some of these different Finnish companies did things just a little bit differently as far as work environment, how they paid people, how they gave them vacations, all these different types of stuff in order to elicit better productivity out of them, which isn't something that we normally think of in the United States as a good thing, because that's always that's something that an employer is giving up. Yeah, and I'm not an expert on the subject, and I don't purport to be an expert on Industrial Revolution era, but it's my understanding that everything was about productivity. They would have people literally come in and a scientist come in and monitor, say, well, you could get 5 swings per minute as opposed to 4 swings per minute if you would do this, and that would increase productivity by 10% across the board. That's not how people are. And I think as the decades have gone on and will continue to go on, for example, to harken back to, you had a great guest on here, and I can't remember his name, but he was talking about, are those hours that you are utilizing, he was talking about the grinding atmosphere. And are those hours that you're utilizing, are you working 10 hours a day? Well, sure.
Worker, yeah.
Could you use those could you get it done in 5 hours and use those other 5 hours for something else to be either twice as productive or spend time with your family? So I think that's a new, I almost want to say new school way of thinking, because I don't think that's prevalent in the workforce. I mean, I think it's getting there with the technology companies and the more progressive companies out there, but I still think there's some pushback from maybe the established, I don't know, the Fortune 500s or whatever you want to call it, but this is the industry, for lack of a better word, to speak generally about the way, this is the way things have always been, and that's the way they need to be. I guess the point I'm trying to make here is that's not necessarily the case. Going back to the quality of work, do you enjoy your work? 8 hours of your day is devoted to work if you are, I'm going to say, lucky. I enjoy what I do, so I think about work all the time, and I work well more than 8 hours a day. And I would suspect that most people who listen to this podcast do work more than 8 hours a day. But you have 8 hours a day of work. You have sometimes maybe an hour or more drive to work, an hour or more drive away from work. At those times, you've got to be thinking about work. You think about it in the morning, you think about it at evening. So you want to make sure that you're fostering an environment where your employee is, like you said, just because it's your dream doesn't mean it's their dream. You may enjoy thinking about your industry 24 hours a day, but your employee may not. So you want to make sure if they are having to think about it, they're not stressed or burdened by it. I think that's important. Happy employees lead to fewer mistakes, right? You want to circle this back around to the legal benefits of it. If they are not stressed out, if they're not tired, if they enjoy what they do, if they pay attention, they're going to make less mistakes, which ultimately is going to be better for everyone. So,
right.
And then other than that, I mean, that's kind of my first bullet point.
Number one. Now number two.
I think kind of getting into more, so maybe we should have said this up top, but the type of law I practice specifically is primarily workers' compensation insurance. I represent a bunch of insurance companies, a bunch of employers. So when their employees get hurt at work, I'm there. You don't necessarily always need a lawyer for it, but if you do, I'm there to help the process along, right? So that being said, something that would be important to me are clear policies. Time and time again, I'll see someone who gets hurt at work and they won't report an injury, which is a big deal in the area of law I practice. And you'll call the employer like, well, did they report an injury? Well, the employer will say something along the lines of, well, yeah, they did, but I didn't write it down, or I didn't think they were serious, or no, I don't take care of that. So-and-so takes care of that. And you'll call so-and-so and he's like, well, I didn't know I was supposed to take care of that. So
it's creating clear systems and clear policies to make sure that's taken care of.
And this stuff seems like common sense, but you can sit down and write out a list of things you need to do on a piece of paper, and you're never going to think of all of them until they pop up.
So why is it important to create those kind of clear systems and clear policies in your business?
Well, I think it all comes back to communication in my perspective, because if you have clear policies, there's no question about division of labor, division of duty, who's responsible for what. So it's important to have clear policies. For example, if you, in my line of work, if you get hurt, you have a certain amount of time to report that injury, 30 days generally. And if you don't, then you as the injured person have a very difficult hurdle to clear, almost impossible. So that being said, so many times an employee will say, and by the way, just reporting an injury is very liberally construed. It could be so much as you tell a coworker that, hey, I went to the doctor because I was hurt. That's sufficient notice in some cases. So that's from the employee side. Now, from the employer side, it's important to have these clear policies in place, because you need to, your employee needs to know, if I get injured, or if something happens, something that could potentially expose me as an employer to liability, the employee needs to know who to go to and who to report that to. And then you can start the documentation process. You can start, do they need medical treatment? Let's provide that right away. Who's responsible for what happens next? So, and if that's not ever discussed, if that's not written down, then you'll find yourself, potentially open yourself up to a lot of exposure.
So when you're talking about doing some of this, so let's say I'm talking to one of the other like small business owners on this thing, and they're like, you know what, my employees are just my friends, and we don't really worry about that kind of stuff that much. It's not that big of a deal. They tell me I'll go ahead and I'll just pay for it or fix it or something like that. I know that's a bad idea. I hope you guys are about to find out why that's a bad idea.
I've seen that happen. So before lawyering in Texas, I was a lawyer up in Oklahoma, and I had a client who had one employee that he knew, gave this employee not only a job and wages, provided him with health insurance, helped him whenever he was down on his luck, paid for a surgery for his daughter. They were friends. They were more than friends. They were darn near family. Well, let me tell you what that did, like how much that helped whenever this guy turned around and sued my client, the employer. I mean, it was just out the window. It was like, hey, thanks for all those free gifts, but also I'm suing you now too. There was no written contract. There were no policies or procedures in place about what would happen. And my client spent a good chunk of change resolving that case.
What's a good chunk of change?
Well,
you can't go specific.
Yeah, it's all relevant to the law, but it was, on top of attorney fees, court fees, which are oftentimes astronomical, and indemnity, so in the form of paying for medical treatment, paying for wages while this guy was off work, and ultimately settling the case, you're well into the tens of thousands of dollars.
Right. So,
and that was one employee for a small company, and that was just because the guy wanted to get some money and go away. If this could potentially be very, very litigious, and this was a minor injury. If it's a large injury, you could run up hundreds of thousands of dollars in medical bills quickly.
So but that's interesting because especially like, let's talk about like real estate agents. They're sending guys out there with signs, something like that. Someone's being, we'll be nice, slightly careless and accidentally puts a sign through their foot, or something along those lines, or they throw out their back while they're trying to put it into the yard, and the next thing you know.
Sure, and that's absolutely a concern. And of course, a lot of it's going to depend on the nature of their business relationship. Are they full-blown employees? Are they what I talk about later, 1099 independent contractors? That's going to have a lot to do with it. But yeah, let's say you are a full-blown employee of the real estate company, and your employer says, or let's say you're the employer, you send an employee out there to stick a sign down, wind blows really hard, he misses and puts it through his foot. That's going to be terrible. First off, you want to go back to his policies. Does he feel comfortable telling you about that injury, or is
Which relates to work environment?
Yes.
Ooh, look at this, we're learning.
Or is he just going to go straight to the hospital and not tell you? Does he think, oh man, maybe I can just walk this off? It's just a sign through my foot. That's no big deal. And then,
as we all do,
the medical treatment ultimately gets worse because you neglected to take care of it sooner. There's so many concerns, but yeah, if you don't have the relationship or clear policies in place where that injured employee could report that injury to you, and then you have a policy in place that dictates what to do next, it's gonna slow the process. And in my experience, the slower these things move, generally, the worse it is. Because the point is, you want to take. I don't think anyone who listens to this podcast, and hopefully anyone who hires someone, you don't hire someone with the intent of being malicious to them or not taking care of them.
That would be a crime.
There's laws in place that say you do have to take care of them. So you got to ask yourself, what kind of employer do I want to be? And in this case,
Scrooge McDuck.
Yeah, that's certainly a possibility. I worked a job. I was an intern, or not an intern, but I was an apprentice electrician one summer when I was in college. And my boss told me one time I had to climb a ladder to complete a connection, and he said, if you fall, you're fired before you hit the ground. And I was like, well, that seems like a weird way to get out of liability, but so I'm just going to try not to fall because I don't want to pay for these medical bills. Of course, I was younger and I believed it, but you can't skirt liability like that, by the way. But
it sounded good.
Yeah, it did.
I was trying to take notes under the table over here.
So again, just relating back to, if you're a real estate agent, if you employ some people, they put a sign through their foot, make sure you have policies in place. I know this sounds common sense, but you'd be surprised. Make sure you have policies in place where that employee feels comfortable approaching you. You know about the injury. because you're going to want to get it taken care of as quick as possible.
So how would you create these policies? This is as simple as like, congratulations, I write it down on a Word document. Employee hurt must come find me and tell me within 30 days, or that's it? Or is this a little bit, is this more like, go find Jace and go talk to
right.
this guy?
So there's, sure, I could plug myself here and say, hire a good attorney to make sure these policies are written for you, which is a perfectly legitimate and probably the best way to go about doing this. But you could also say, it comes from experience. You could maybe snatch a policy from one of your former employers on the way out the door while you go start your own company. But I want to be clear. There's multiple things at play here. There's usually a lot of times people will have insurance for things like this, right? Mm-hmm. But what the insurance does once they get word of the injury is different than what you should do as an employer once you get word of the injury. Right. So it just needs to be common sense. I mean, we're not talking about a 100-page manual on what to do when you report of injury, but there needs to be a clear hierarchy. There needs to be a clear division of labor. There needs to be there needs to be a clear set of rules that say, here's who you report to. Anything out of the ordinary, if you get hurt, tell your immediate supervisor, And
I'm guessing these policies need to include things like, congratulations, you found a love interest in the office, and later, you need to go tell this person. So these policies need to cover pretty much anything and everything that could possibly occur. And is that normally like part of HR systems and stuff like that, or?
Yes.
Yes.
So, yes, there are obviously more than one concern. Employees getting hurt at work is just one concern. Relationships that develop at work, that's going to be an internal policy. I know married people who work together. I've worked at places where their love was too much to be contained. It was just unbridled, and one of them it was against policy, so he just quit working there so he could be with the love of his life. And to this day, I don't know if they're together or not, but that's beside the point.
That was very romantic of you. Congratulations.
It's going to be an internal decision. That's going to be something you said. There's nothing against the law that says you can't, be in a relationship with someone you work with. Like that. That's not a concern. It's just, you have to ask yourself, is that going to be best for you? Do you care? Do you want to work in a place where you can't work with someone you're in a relationship with?
Right, but as you were saying earlier, it's all about decreasing exposure at the end of the day, correct? Yes,
it is. So now, if you want to get into, let's just, I think we're dancing around the subject, and if you're talking about sexual harassment claims, I don't hold myself out as an expert on that area of law. I try to just be a good person, and I find myself like not getting involved in things like that. The law is not.
Sorry, that was too awesome. Just try to be a good person, and you should be okay.
Sometimes the simple answer is better than the legal answer. It's not, a lot of this stuff isn't rocket science. It's just, you don't lose your common sense just because all of a sudden you find yourself caught up in a lawsuit. Now there are nuances, and you can navigate statutes, and there's exceptions and all that. But generally, just common sense ideally will prevail, or should prevail most of the time. What can you do to guard against? If you do want a policy, I know there are examples. You can't deny it. There are examples of people being vindictive on both sides. Whether you're a man, whether you're a woman, you play this "I'm going to get you" game where it's been consensual up until one point, and then one person says, "You know what? I'm not into this anymore. I'm going to report you." I don't know what you can do personally to protect against that. Now, if you want to play it safe, you can just have a carte blanche ban, no relationships in the office. Sure. That's all going to come back down to your work environment. What type of people are you hiring? Do you know these people? I know you said something earlier about working with your friends. That's certainly might even be preferable in a lot of people's cases. You know them, you know their work ethic,
right? Because
ideally they've been your friend for a while. To harken back to one of your older podcasts or your earlier podcasts, are these friends moving in the same direction as me?
Does this guy go and watch all of our podcasts? I'm really impressed.
I did. I literally had nothing else to do. Believe me, I looked for things, and I'm just kidding. It was very informative. Even so, and I think I told you this too. maybe something else I should have plugged at the top, but I'm not a business person. I do have my law degree. I do have my MBA also. I was a business major in undergrad. I consider myself having a business mindset. And what I mean by that is, here's a problem, here's a solution, go enact it. As a lawyer, you can't do that. You have to say, here's a problem, here's 50 different solutions and why they may or may not work and why the subparts of that. And I don't feel like I'm wired for that. It's something you have to work at. Yeah, I think a good segue into having clear policies, I put its own title, document. And that's going to be an internal decision, but it's not only for CYA purposes, right?
So what is CYA?
Cover your ass. For those who don't know, you should just get in the habit of documenting everything. Phone call. So I'll get a call from a client and we'll agree on a plan of action, but I immediately send a letter after saying, hey, this will confirm our phone call on this day where we discussed X, Y, and Z, and I have authority to do this.
So emails, that's documenting.
Emails documenting. Letters are documenting.
Photos?
Photos. Of course. Oh, yeah. I'm sorry. I'm thinking in my context, like, I don't know how I'd use a photo to confirm anything, but yeah. Photographs.
Photos, video, all that kind of good stuff.
Yeah, so you want to make sure that you document, and that ranges from new employees. You want to make sure that they sign, that they got all their material, and that you went over policies with them. To working with clients, you want to make sure you sign. You're a real estate agent, and you are talking to someone who wants to buy a house, and they say, I'm looking for X, Y, and Z. Send them an email saying, hey, this will confirm you're looking for X, Y, and Z in this neighborhood, or in this area. And that way, when they say, well, I wasn't looking for this, you can say, respectfully, well, okay, I misunderstood because you told me this is what you were looking for. So it's just always good to document. For as an employer, one of the reasons that I use is if you have to, I think the word here I used, unhire an employee, they'll oftentimes seek unemployment benefits.
That's like so opposite of the way like all my clickbait works. Like how to fire your employees in the next 90 seconds. Never mind. Excuse me. Unhire.
If you have to, well, the word we use in my line of work is terminate, which I think is a bit harsh because he's like, I'm going to terminate this employee. He's like, I used to be a prosecutor, so I'm like, wait, the criminal law in me is like, when you say terminate, just so we're clear, you mean like fire, right? You're not going to terminate. You're not going to go Arnold Schwarzenegger on them.
Termination.
So what I would say is, why it's important to document. For example, if you have to fire an employee, terminate, unhire, whatever you want to use, they will oftentimes go to the Texas Department of Labor. They're going to seek unemployment benefits, right? And what the Texas Department of Labor is going to do, they're going to call you and say, hey, why was this person terminated? And you're going to tell them, oh, well, it was poor job performance. And they're going to say, well, what do you mean poor job performance? And what steps did you take to ensure that their performance was getting better? Right. And if you can sit there and say, well, I just told them over and over again, if you can't demonstrate any substantive training or anything, then can it actually be said that they were ever trained to do their job?
And this guys is what I've talked about before when I've talked about like you must have PDMs, personal development meetings with a full written out deal. Like this is what I need you to improve on, and signatures at the end. And you need to have those on a like weekly basis, a quarterly basis, a 90 days review, all that kind of fun stuff. Because I'm guessing that covers your ass.
Yes. CYA procedure. So I think it's important, because if I were representing that terminated employee and I found out that the employer didn't provide adequate training, so you fired them for no reason. You said they didn't do their job, but you didn't train them to do their job. How can they do a job that you did not train them to do? So I think it's important to document that, like you said, keep a file, keep those the personal development meetings,
PDMs,
yeah. So it's good. And as an attorney, if I can come back and say, well, what steps did you take? Give me their personnel file, which we'll get to in a minute, and you hand me a stack of write-ups, things they need to work on. That's going to do leaps and bounds to help me help you. So
right.
It's important to document. Other than that, that's really kind of all I have for clear policies, documentation. Again, I know this sounds it may be remedial to a lot of your.
Well, I think a lot of times people get so caught up in sales and all the other pieces of their business that, you know, I was having a conversation today, which was that I'm really glad that no one looks at small businesses quite as closely as they should, because most people are out of conformity when they start up, right?
Yeah,
they are, you know, and it just is what it is, because, and a lot of times that's just because there's just such a steep learning curve to when you're actually getting into business. You're like, you know, if you're starting up and you don't have a lot of capital or anything else, you're like, can I get food on the table? Can I get bills paid? Can I get this stuff done?
Well, and you're playing several roles. You're wearing a lot of different hats as a startup. You're HR, you're supervisor, you're CFO, you're CEO, you're the main guy to go to. So.
Right. Even if you even understand what each one of those individual roles are and what they actually mean, right? It's all part of that learning process. So I think there's a lot of people that get, you know, several years down the road, and then they end up in these positions where they're like, oh crap, there's a whole nother list of things, which I thought was a bunch of corporate bullshit, which is actually here to actually, you know, help me out at the end of the day. It's here to keep me safe. And yet when you're trying to grow, like there's a bunch of people on this that listen to this. They're like, I want to expand. I want to grow my team. I want to put it in multiple layers. And here's the deal. This stuff, all this minutia right here, is the one thing that's going to keep you from one incident that will sink your freaking little ship. Congratulations, all the way to the bottom of the ocean. You get to start all over again.
Well, and I think what echoes that is you don't know what you don't know, right? Because say no one gets into business to fail.
I tell my wife that all the time. She doesn't believe me.
No one gets into business to fail, but you don't necessarily, maybe you have a 5-year plan, but not a 10-year plan. And here you find yourself 7 years down the road, you're successful, you're thinking about hiring employees. Well, as I said earlier, you've always worn all the hats in the business. Now all of a sudden you have to delegate and you have someone else. So you haven't needed these policies and procedures, but now you do. So it's just something to be cognizant of, be aware of, you know, be thinking about it in the future.
Right.
I included this because I hear people use these terms incorrectly, and I just thought, you know, maybe we can do a little, the more you know star come across. People often say right to work versus employment at will. And I think they say that without knowing what that means.
So you're talking about union versus non-union? Is that what we're talking about?
Yes, essentially, because, you know, people equate right to work with, oh, I can just fire you at any time for any reason. That's not what that means. Right to work, it comes out of the 1935 National Labor Relations Act. And it basically just said that it depends on what side of the V you're on, right? But, you know, some people said, well, I have a right to work. I shouldn't have to be a member of a union. I shouldn't have to organize or participate in organized activity to work. I should just be, I have a God-given, or whoever your creator is, but I have a God-given right to work. And I'm going to do that, and I don't need to be part of this big company to work. The other side of it is going to say, no, the employer takes advantage of the individual, and you need to be part of us to make sure that you're getting a fair wage. And then the other side will come back and say, well, just because you want to work for $15 an hour, I'll do the same job for $10 an hour. And I mean, the back and forth. But essentially, Texas, along with several other states, is a right to work state, and all that means is it does not require a union membership to work. Does not require an individual to participate in collective type activities. Now, contrast that with employment at will. Employment at will is essentially those employees whose employment is not governed by a contract, right? So if they're employment at will, you can terminate them with some exceptions I'll talk to.
So what would that look like are we talking like day labor or
that's a great example. That's what I was going to say. Day laborers are employment at will.
Are 1099s employment at will or no?
Well, they're their own kind of unique subsection, because I would argue 1099s are that's exactly what they're contract workers. They're not employment at will. They and as I say in just a minute, there's no such thing as a 1099 employee. They're not your employee. They're a contractor. So I think it's a bit of a misnomer to say 1099 employee.
And just for those that are listening outside the United States,
it has to do with it's a tax classification. And keep in mind, you're getting this advice from someone who made a C in tax law. Because I lost...
Never mind, I'm giving the definitions.
No, this is a funny story, though. The reason I made a C is because I lost my tax book right before the final. and I did not want to buy another one because they are very expensive. So I went to our law library, and the most recent copy they had was from 1995. So I prefaced every answer on my exam with, in 1995, this. And I think the professor just gave me a C to take pity on me because I needed it, and I didn't want to retake that class. And I don't think he wanted me to retake that class. So, but no, 1099 is a classification for tax. It's where you withhold, essentially the 30,000 foot view is you withhold your own taxes. There's no one taking the taxes out for you. You're doing it by the job. You're saying it's going to cost you X amount of dollars, and someone pays you X amount of dollars, and you're responsible for the taxes that you made on that job that you have to send off to the government.
Got it.
So, going down, I said employment at will means you're an employee without the protection of a contract, but there are some instances you can never terminate an employee based on protective classes. For example, this is important. You can't terminate an employee based on sex, race, religion, national origin, if they're subject to the Americans with Disability Act, or gender or age. And I put some exceptions there because for example, pilots all the time have to retire at the age of 60, right? From the public or from some of the big companies. You can fly privately well past the age of 60. That's one example. Another example, this one stands out for me from law school, but you necessarily can discriminate. For example, if someone is a woman working in an all-male penitentiary, right? You wouldn't necessarily want that for any number of reasons. I'm not here to give an opinion whether that's right or wrong. I'm just saying there are some instances when you can discriminate based on age and gender. Those are two that come to mind, but the other ones, religion, national origin, those are no-nos.
I wouldn't try doing that without a lawyer present. Hey.
I also want to talk about contract employees. You can fire a contract employee, but you're going to open yourself up to a lot of litigation. It's just, be sure what the contract says. Are they in breach? Are you in breach of the contract? That's something to be aware of.
Yeah, if you're going to write a contract, you better stick to what the contract says.
Yes, absolutely. So, non-compete clauses are always the big one that I see. Someone sells a company or they get hired at a company, and you have a non-compete clause because you may be able to, maybe your contract says I can quit whenever I want to, but I can't go compete against this business for 5, 10, whatever years in perpetuity. So,
right. So, especially now, this is kind of fun. So, especially when we're talking about non-compete clauses, I have seen some whoppers of some non-compete clauses. Not always legal non-compete agreement, but I have seen some pretty scary non-compete agreements out there.
Right. I think there's a fine line between non-compete and then any contract employee and then just straight up indentured servitude, which is not illegal. So, you have to be careful about it. Make sure it's one that's, if you're using something like that, make sure it's withstood the test of time. Make sure that you used it before, or make sure you have someone who knows what they're doing look it over before you just say, because, man, lawyers are the worst because we will nitpick and nitpick and nitpick. And you may think I've covered every possible scenario in which this employee can and cannot leave employment. And I guarantee there's going to be someone out there who says, well, you didn't think about this. Yeah. So it's just, it's just one of those things you have to be aware of as an employer. So
as an employer, it's good to, if you're going to do a non-compete, you need to find out what the non-compete is for your state. You need to figure out what that actually looks like. Please just go find a lawyer that actually will write it for you. Don't go on to Rocket, lawyer.com and then download one. It's just. I will say, generally speaking, courts usually look favorable and they'll do their best to enforce a contract because something that stuck with me is freedom to contract is freedom from contract. No one is forcing you. Okay, say that one more time.
Freedom to contract is also freedom from contract. And what I mean by that is no one's forcing you to enter in that contract. You can enter that contract or you cannot enter into that contract. And if you do enter into that contract, it's because you're getting consideration for it. You're not just doing it and not getting anything back, not getting anything in return. So courts usually, contracts make the world go round, right? Whether you're importing, exporting, selling houses, any number of things, buying, selling goods. So courts usually will do their best to, in my experience, enforce a contract as long as it's, not unconscionable or illusory or anything like that.
Which means?
Unconscionable means it means it shocks the conscience, means like, I can't, this is not right. The court will say this is not an equitable, like this is not a fair deal. Or if it's illusory, it means it's an illusory promise. It says, we promised you this, but there's no way we can deliver it. Or it doesn't stand. It's not right to enforce this.
Right. So the unconscionable would be, you cannot practice coaching within 4,000 square mile radius from the aforementioned company.
Well, you may say that's or your employee may say that's unconscionable, but I guarantee there's going to be a lawyer out there who say no, that is conscionable. That's fine. So there you go.
Which I think probably also comes down to the state.
Yeah, sure. There's going to be contracts is a common law type of deal. So unless you're buying or selling goods, that's generally statutorily regulated. But contracts are going to be governed by common law precedent, case law, things like that. What's happened before? What have we normally done in this situation?
Right.
So, just something to be aware of. And I talk about contract employees. I want to make a distinction here. That's different than I'm using that term differently than a 1099 employee, who is someone independent of your company whom you contract with to do a specific job, right? A contract employee, think like a CEO of a Fortune 500 company. They have a contract that says you will work on this day, we will pay you this much money, you have these performance goals, et cetera. That's all going to be written down in a document. If we fire you or you leave, here's the provision about your golden parachute. This is what you're entitled to when you leave this company, especially if you hit these performance goals. Contract employees, professional athletes are a great example of they sign contracts every year. You always hear about that. They're holding out for a better contract. They want more money. They want more control over their brand, their name, things of that nature. Now, a 1099 employee, again, I say that's a misnomer. There's no such thing as a 1099 employee. What you have is independent contractors. And so kind of the test I like to use is if it looks like a duck and quacks like a duck and acts like a duck, it's probably a duck. Is this person really a contractor, or are they your employee? And so the courts, what they've done, there's some tests that they look to. They, for example, there's no clear-cut answer, and there very rarely is in law, unless you get to crime, like don't speed. Did you speed? Yes. It's a yes or no question. There's no exceptions to that. Now, when you get to things like, is this person a 1099 independent contractor? Well, maybe. Let's look at the factors. And some of the things they look at is, who provides the tools to do the job? Who sets the terms of how the job is done? Where is the job done? I just went blank. What's my outline here say? It says, are you restricting that person's ability to work elsewhere? So
can they get a job? Can they hold multiple jobs at different places?
Right.
So if Joe Smo over here wants them to do something, can they actually go and work and do something with them? Are they working from office or are they working from home? Are they working? I was going on the list backwards.
That's fine. But who sets the schedule? If I hire,
you have to work in between 8 and 5.
Yeah,
Monday through Friday.
And this is
probably not
kind of an absurd example, but we deal in the absurd a lot of times. Say a roofer comes and wants to repair your house. And you say, okay, I agree, repair my house, but here's the tools I want you to use. Here's the material I want you to use. You need to be here between 8 and 5 every day until it's done. Mm-hmm. You cannot go work on any other roofs while you're working on this. I mean, are they really an independent contractor or are they your employee? So Those are some of the questions you have to ask. Because going back to employees, well, before we get there, I just think that's important. So I think,
but I think the last one also kind of, you get into that where, okay, so I've worked for some companies where they've written down while you are subcontracting underneath this, you cannot go work for some of these other companies as a non-compete clause, right?
Right, and that's protecting trade secrets, but or that could be a case where you're protecting trade secrets, for example.
Right.
That's an interesting question. That's one I don't know. I haven't come across that, but no, that's exactly right. It's not necessarily that we don't care if you go earn income otherwise. We just don't want you to tell the other people what we're doing. That makes sense.
Yeah.
So yeah, I don't know. That's an interesting argument. So.
Yeah, I don't know. It's something I've actually seen where I was like, they were like, yo, you can't go do video for any other company in this industry while you are, doing any of our, working with any of our videos. We weren't, it was still videos here and there, but they were just like, if you dare.
Yeah.
And I was like, oh, well,
yeah, but
but all right,
that's
cool.
a double-edged sword, because if you wanted to be nefarious about it, if you're looking at it from that point of view, and in the 2 seconds I thought about this, right? You don't want them going to work for someone else because they may divulge your secrets. But the flip side of that is if they go work for someone else, then they can divulge your competitor's secrets to you. So I don't know. It's an interesting question.
Yeah.
Thank you for asking it.
You're welcome.
I don't know the answer. But I think this is also important because it gets down to my last point, which we are not there yet. But one of the things I'll talk about at the end is wage theft. And you don't want to avoid paying wages or taxes just by misclassifying someone as a 1099 contractor, right? You don't have to pay them taxes. They have to pay their own taxes. But if it turns out they're not a contractor, they're actually an employee, you need to pay the taxes on them.
Right.
So that's one concern. So jumping back up, something that employers need to be thinking about, and this kind of ties into your policies and procedures too, but you need to be cognizant that these people you're hiring are ambassadors for your company, your brand, your business. And do you have something in place that, with regards to social events or social media, what are your policies on that? Do you care what they post in their private time when they're off the clock? Do you not? Do you make them like certain things on Facebook But yeah, just be aware of the type of people you're hiring, because these people are going to be representing you out in the real world. Whether you run into someone at the gas station, if they're in a company truck and they, are having road rage, and there's any infinite possibilities, obviously, but it's just something to be aware of. Also, as employees, these people can be agents of your business. So you need to be careful about how much authority you actually grant to your employees, because these people can enter into binding contracts on your behalf, whether you know it or not. So,
yep, I found that I have a personal example of that one.
Do you want to share?
Oh, sure. Why not? I already settled that case. Had an instance where an employee started a relationship with a music company and did not tell me about it, and then ended up not paying that music company while we were using their music. Didn't find out about it until after the employee was terminated, and I was in the middle of a lawsuit.
All right, so
welcome. I didn't do that. That wasn't me.
Yeah,
I was still very much responsible for the payout at the end.
So again, just go over your, hey, you don't have it. Run all contracts by me, for example, and sign here saying that I told you that. That'd be a good, that might be best practices. So, and maybe your employee didn't even do it maliciously. Maybe they saw what they thought was a great opportunity and they thought they were doing you a favor, but maybe they aren't as experienced as you.
You didn't do me a favor at all.
Maybe they aren't as experienced as you. They don't have all the facts that they should. There's any number of reasons why that could go south in a hurry. So just be aware. There's so much to worry about as an employer. I couldn't imagine.
Let's see, that was something else we were talking about earlier. We said that if anybody, like if you're really starting to, you were like, you know what, I think I'm going to own a business. I'm going to be the best entrepreneur ever. And then you like got into all this and we like showed you the stack of crap. You'd be like, Lord, get me back to being an employee. Like that crap's for the birds.
Responsibility? No, thank you. So that's those are just some things to be aware of with regards to your employees. So also put on here, just because it's kind of what I do, I feel like I should talk about it. Do I need workers' comp insurance?
No, you don't need insurance. There's no such thing. You don't need insurance.
I will say Texas is unique, and it's the only state that does not mandate that you have workers' comp insurance. But
do you need it?
Well, it depends. It's a cost-benefit analysis. I would argue generally yes. I think it's better safe than sorry. But a lot of, so I'm not going to go into any specifics, but what a lot of the big companies did is once Texas made it to where you didn't have to subscribe to have workers' comp insurance if you don't want to, they did a cost-benefit analysis. Said, okay, how many people are getting hurt each year at work? what are we spending to defend those cases and pay them out versus what if we just took them to court? And because if you don't have workers' comp insurance, it becomes basically a negligence lawsuit at that point. But the employer is put in a very severely limited and handicapped position because you don't have a lot of your defenses available to you. In fact, you have very few defenses available to you. So, which is why it kind of behooves you to have workers' comp insurance. But all that to say, a lot of these big companies came in and they did a cost benefit analysis, and they found out it was cheaper actually to not carry workers' comp insurance, to not pay the premiums and everything, and just go to court and defend these civil litigation lawsuits, essentially these negligence cases, because they found themselves, even when they lost, they were still not paying out as much on the whole as they were for insurance premiums and things of that nature. But that works for big companies. But it may not be what's best for the smaller company.
They might be looking at it like, however many millions of dollars they were shelling out a year, and you might be looking at it like, but I think like with a little company, that doesn't have like millions of dollars, and they're sitting there and they're like, oh crap, like, $10,000 bill will break me.
Yeah. You're just, one bad, God forbid, one bad medical accident away from shelling out hundreds of thousands of dollars in medical treatment. Okay,
so what if you're hypothetically, let's say you're a sole practitioner, right? Should you also basically have workers' comp for yourself?
I wouldn't if you had health insurance. That's just my personal opinion. If you're a sole practitioner, there's no one else in your office, I wouldn't.
Cool.
Yeah.
Who knows? I'd be.
I'm going to look to my off-camera expert here and get some assurance on that. Okay. Yeah. Sounds good. All right. So that's just kind of the brief. I find it funny. That's what I do for a living predominantly, but I think that's the subject I want to speak the least on, just because I don't want to, I think too much farther into the woods, and I don't want to. Legal advice is very tailored to a person's specific needs. So I don't want to say something that may work for one person, but it may not work for another person.
Right.
And then they come back and say, well, that lawyer told me I should do this. And then
everything in this whole segment goes underneath this following statement, which is go do your own research, go do your own stuff, go figure out your own way, go talk to your own lawyer, figure out what is right for you. And the views and opinions that are stated herein do not necessarily reflect the views and opinions of Hero Nation in general. Thank you very much.
So I just have two more broad points to talk about with regards to managing your employees. This goes back to document. But personnel files, I think it's smart to keep a personnel file on everyone from the CEO down to your newest hire, whatever role they may play in your company. But and sure, I'm sure a lot of these people out here, maybe they do keep it. Maybe they do have at least the hire paperwork in there. But you need to be smart about how you keep your documents. So documents which contain sensitive or protective information, you might want to keep separate from hiring records or general just performance issue records. Sensitive information, I-9, so resident status forms, citizenship documents, medical records, maybe even tax forms. That's going to be kind of subjective, but you need to have them compartmentalized even within the personnel file. It's not say, oh, well, I keep the personnel file under lock and key. Well, I keep the personnel file under lock and key, and I keep subfolders that are very clearly marked confidential in there, or whatever the case may be. Usually, most of the time, you're going to keep all the files together. It's personal preference, but most of the time I see wage records are pretty much the only thing that are kept separate, only because those are mostly electronic, and they're either done by a third party who manages the wages, or HR who just has them on a spreadsheet or on the computer elsewhere. So they're not kept in the personnel file necessarily. But so you want to keep separate documents for sensitive, protected information versus performance information versus payroll versus hiring records, etc. So
nice.
That's pro tip.
I like it. There's a lot of systems here. There's a lot of good stuff here.
Because you don't want to find yourself running into any HIPAA violations, for example, by disclosing any medical information or Americans with Disability Act information or things of that nature.
Right.
Because again, you can open yourself up to exposure, and we want to minimize that.
Exposure is bad. I will tell this to the nudist colony nearby.
And where is that? Just for research purposes? So, lastly,
I can't divulge that here and now.
Lastly, wage theft, I think, is probably the most, in my opinion, egregious and most criminal act on here. And thing that can be done both intentionally and unintentionally. We touched on it earlier about misclassifying employees as 1099 subcontractors when they're really full-blown employees and you need to pay taxes on them. Also, you might be violating minimum wage requirements without knowing it. I know that's a hot button issue depending on what part of the country, and they're always talking about who has the highest minimum wage. Does it need to go up? Does it not? But it's something, keep your finger on the pulse with regards to that. It's also, you may have, maybe you're simply asking an employee, hey, can you just help out? I know you're off work, but if you could just stick around for a few more minutes. I know you're off the clock, but if you could help me do this, and you don't pay them for that could come back to bite you in the rear. So something to be aware of. And lastly,
that was going above and beyond.
It is up until you get one disgruntled employee who says, well, I did all this work and you didn't pay me for it. And I'll let you sort it out with EEOC or Department of Labor or anything like that. Lastly, simply not paying employees. That's a big no-no. You're not really allowed to do that. Last I checked, I think you have to pay people for the work. But more nuanced than that, maybe it's gender thing. Maybe you don't pay, for whatever reason, you don't pay the women as much as the men in your office, or vice versa. Then you're opening yourself up to not only this wage issue, but discrimination issues, which it can balloon out of control quickly. So you need to have policies in place. You need to have written policies. You need to have just a clear designation of what you want to do, what you want to achieve, and how you're going to achieve that.
Okay. And I'm going to throw this last one in here, which I want to connect with the wage and with policies. Now, I've seen this a bunch of times where employers try to, and you can't do this, where employers try to do something along the lines of like, hey, here we're going to do your we'll say it the non-PC way. We're going to do your firing paperwork today, and you need to sign these pieces of paperwork, otherwise you don't get your last check.
Oh yeah, no.
I've seen that a bunch of times.
Don't do that. If they want to refuse to sign the documents, that's on them. Just make sure you document that you told them about the. And usually I'll just see like called employee on this day, they refused to sign. And make sure maybe send that termination paperwork to them certified mail. That's one way. I mean, the mail for whatever it is, I think it's still around. It has its purposes.
Right. But you can't force anyone to sign anything, especially like non-competes and stuff like that at the end of the deal. Yeah. In order to get their paycheck.
Right. Yeah, I wouldn't do that.
Yeah.
So if they work those hours, even if they're a terrible employee, they work those hours, they're entitled to that compensation.
Yep.
You need to separate that. For me, that's a separate issue. Whether or not they're a terrible employee has nothing to do with whether or not they earn those wages. So, I mean, now, sure, there's questions like, well, he wasn't really working, and so I don't think, he should get this money. That's a separate issue. But if they were working and then they came in and an attorney I work with, he likes to say they resigned creatively. He says, if you walk in and punch your boss in the face, what have you done? You committed an assault, sure, but you've resigned. You've done it in a creative way, but you've resigned. So maybe they did the work. They did good work. You didn't see eye to eye. There was a falling out. Make sure give them the money that they made, and then sort out the other stuff later. So
nice, cool, dude. This has been a fuck ton of information.
Yeah,
it's good information. Dude, I really appreciate you coming in.
I was happy to. Thank you for inviting me on. I know I'm kind of a different area than what your target audience is used to, but I think it's important that we're all young professionals here, and we can all learn and benefit from each other. And I hope we continue to do that through Hero Nation.
They need to get a hold of you, your firm.
Yeah, sure. So again, my name is Jace Powell. I'm with the Silvera Firm in Dallas, silveralaw.com. You can look me up there. jpowell@silveralaw.com is my email address. I'm on all the big sites, Friendster, Zanga, MySpace. You can find me there. So anyway, if you have any questions, I'll do my best to answer. If I don't know it, I'll be sure to try and get you over to someone who does. So
sounds good.
Yeah.
Guys, until next time, be your own hero.